Santosh, what exactly is the priority date means here?
Okay. So priority date is the date when the applicant actually files the labor application. Okay. So if they're going through the perm process, it's a date they file the perm. Okay.
Okay.
If they're directly going for I-140, for example, if they're filing under national interest waiver or so, then the date will be the date when they file the I-140. Okay.
Okay.
So once you receive the approval I-140 approval notice, that notice will have the priority date for the person. It will also state the employment category under which the I-140 was approved, whether it's EB2, EB1, or EB3. Okay.
Yeah.
So once someone's priority date becomes current, okay, and if they are present in the US at that point of time, they can file for what is called adjustment of status. Okay. So when they file for adjustment of status, along with that, they can also apply for EAD and advanced payroll, which will allow them to work as well as travel while the green card application is still pending with USCIS.
Okay.
Okay. If the person is actually outside the country, outside the US, okay, then they cannot file for adjustment of status.
Okay.
So those people will have to go through consular notification. Okay. So do you have any questions regarding this part, or?
Yes. Yes. So you also asked, told us about like a priority date is current and that thing is covered. And could you please explain about this? What exactly this October 2020 Visa Bulletin is all about?
Sure. So what happened is, because of the proclamation order, a lot of green card cases, family-based green card cases, were not processed. Right. So since they were not issued, the green card, family-based green cards were not issued. So there is an overflow of these numbers which were transferred to the employment-based.
Okay.
Hence, the dates have moved drastically. So now, if you look at it, the priority date for EB2 India is May 11th of 15th May of 2011, and EB3 is 1st Jan of 2015. So anyone who has an approved I-140 with these priority dates, right, or any date before these priority dates, they're eligible to file for adjustment of status now.
Okay.
Okay. And this does not mean that they're going to get the green card right now. It could be years before they will get the green card, but at least they can file for adjustment of status now.
Okay. Yes.
Okay.
So,
yeah, go ahead.
So, and initially there were some rumors about this dates, right? Which dates to be used. So, what is all that about?
Okay. So typically the Visa Bulletin is issued by the Department of State. Department of State is the agency that issues like visas and the visas, right? So Department of State has issued the Visa Bulletin, which will have the final action dates as well as dates of filing. Okay. Once that is issued, USCIS will confirm whether we need to use the final action dates or dates of filing. If they don't mention anything, then we'll have to go with final action dates. Until September 2020 Visa Bulletin, USCIS was always using the final action dates. But luckily, in this Visa Bulletin, they have agreed to go with the dates of filing, because of which the dates have moved drastically. So now all those individuals who have their I-140 approved, right, and whether it's under EB3 or EB2, right? If it's under EB3, if their dates is anything before Jan 1st of 2015, or if they are under EB2, and if they have priority date anything before 15th May of 2011, they're eligible to file for adjustment of status. Okay, I know it is slightly disadvantageous for EB2 category individuals than EB3 category. Okay, but there is an option wherein if somebody with EB2 category and their priority date is in like 2012, 2013, right? They can port their priority date from EB2 to EB3 and file for adjustment of status at the same time. Okay, This can all be done at the same time, so there is no waiting period. So I'm telling you all this based on some of the questions that I've been receiving in the last 2 days.
Yes.
So
Even
there is no premium processing.
I have a couple of questions for you.
Yeah, sure. There is no premium processing available to process an application from EB2 to EB3 because you may not have the original labor with you. But you should be able to file for the I-140 application as well as the adjustment of status concurrently. Okay. And that will work.
Yeah.
Okay. So you don't have to do a new perm application because you'll be able to use the old EB2 perm to file the new I-140. Go ahead, Kit.
What about EB3? EB2 May 2013 priority date people, Santosh? Like,
yes.
Do they have any options for that?
Yes. I was speaking to, yeah. So as I mentioned, right? So for example, if somebody has EB2 date of May 2013, right?
Yes.
All they have to do is they have to file the I-140 and adjustment of status together. So this I-140 will port their priority date from EB2 to EB3. So now, since EB3 2013 is current, they should be able to file adjustment of status at the same time.
Okay.
So they don't have to go through the perm process again, but they just have to file this I-140 application. Their employer would be signing the I-140 application along with the adjustment of status documentation, and then we'll submit them concurrently.
Okay. So, for filing this adjustment of status, exactly do we need to be in US, or if someone got stuck in India, so what about them? In this meanwhile period?
Yeah, you have to be in the US in order to file for adjustment of status. Unfortunately, there are a lot of individuals who are stuck in India right now, especially they have a few clients wherein H4 individuals got stuck in India. So they are pretty much out of luck because the only way that they will be eligible is if we request for consular notification by filing something called 824 form. Okay. But that will probably take months, and by then the dates will retrogress. Okay. So if there is anyone who is stuck in India or any other place, so I highly recommend that they travel back to the US as soon as possible. Okay, and travel back on H4 or H4, not on B1, B2, because if you travel back on B1, B2, then you'll be subject to the 60-day, 90-day rule, which could affect your case. So I recommend that you travel back on H1 or H4, and then file for the adjustment of status.
So and are there any we are hearing many things about date of birth certificate? So is it that mandatory, and what are the other options if someone not having this date of birth certificate?
Yeah. So for example, if somebody is born after 1970, right? The typically date of birth, the birth dates are considered to be recorded. So if a person is born after 1970 and does not have a birth certificate, then they can get a non-availability certificate, okay, and use their matriculation certificate or affidavits from parents or whoever, right? Whoever has first-hand knowledge about their birth, they can use that. For filing adjustment of status right now, if you do not have it handy, do not panic. Okay, still go ahead and file the application, and by the time you receive an RFE, you should be able to gather all those documentation and submit it at a later point of time. Okay. So as long as you have some proof to show that you were born in India, of course the passport is there, and then you'll have some matriculation certificate. Try to use whatever affidavits. Try to use whatever you have, and then submit the application. And then once there is an RFE, at that point of time, you'll be able to get the non-availability certificate.
Okay.
Sure. And if you have the birth certificate, it's very easy. And again, I actually had a citizenship case wherein the birth certificate, I don't know how they got it, but they got it from some Gram Panchayat person. And it was so when they went for checking the certificate, it was not an original one, or it was not properly recorded. So please make sure whenever, like I'm sure like there are a lot of people who will be working using some agencies to get their birth certificates, but please make sure it is proper, like you can actually verify the information online before you accept any such birth certificates and you submit it to USCIS, because they will be checking everything.
Yes. Yes. And also about medicals. So during this COVID situation, like what about having medicals? Like, is it mandatory for the medical also for filing this?
So
And how the
medical,
validity of this medical is like
yeah,
about
yeah,
the validity of
yeah.
medical?
So when it comes to the medicals, right, you can either submit the medicals at the time of filing the petition, which is now, or when you receive an RFE, or at the time of interview. Okay,
Okay.
right?
Yeah.
So if you do not submit the application, the medicals now, you will not have the option of submitting the medicals anytime until you receive this RFE. Okay.
Okay.
And if for some reason you're outside the country, when you receive this RFE, you cannot get the medical stamp, because the medicals done abroad will not be considered for filing adjustment of status.
Okay.
So if, for example, if somebody received an RFE and they are traveling abroad, or they're in India or somewhere, right? So they'll have to travel back to give the medicals. So
Okay.
if you want to avoid that situation, then please go ahead and submit the medicals now. But again, there is another catch here. You have to submit the medicals to USCIS within 60 days of obtaining them. So once you get the medicals, you have to submit it to USCIS within 60 days. And the medicals are valid only for 2 years. So if your application is not reviewed within the 2-year period, then they might again anyways issue the RFE. Okay.
Yeah.
So in this court situation, it's up to you whether you want to submit the medicals now or at a later point of time. But these are the challenges that you could face in future.
Yeah. So, and also, what are all other documents, Santosh, that everyone need to be ready with for filing this?
Good. Typically, we have been sending checklists to everybody. One
Yeah.
of the things that I want to make sure they all submit is the I-944 form, which is the public charge liability form. I don't want anyone to miss that one, because that's very important. And there is a chance that they might even reject the petition if you do not submit the I-944 form. So it's very important that you file the I-944 form. And so all the primary applicants, for example, like when I say primary applicant, the actual employee. Okay,
Okay.
the employee needs to sign the I-485J application, and their employer also has to sign the I-485J. So unless your employer signs the I-485J, your petition would not be considered.